Okay, let's unpack this. We are diving into a really complex and, frankly, pretty painful story today.
Yeah, it really is. It's all about history, ownership, accountability, centering on Harvard University and some, well, incredibly important and very old photographs.
Right. And for this deep dive, we've got some solid sources. We're looking at legal analysis from a law review article, which really breaks down the court cases.
And also details from Harvard itself, from their museums, their initiatives looking into the university's connections to slavery.
And then recent news reports that cover how this long-running lawsuit finally got resolved.
Exactly. So we've got a good range of perspectives to draw on.
So our mission really is to get to grips with the whole journey of these specific images. We want to trace the legal fight, explore the tough ethical questions they raise for institutions holding on to this kind of history.
And figure out what this recent settlement actually means for everyone involved, and maybe what it signals for the future, too.
Yeah. Get ready for some, I think, surprising facts and some really crucial insights into how we grapple with the past. So let's start right at the beginning. The photographs themselves, we're talking about daguerreotypes. These are super early photos, right? About 175 years old now.
That's right, made way back in 1850 down in South Carolina. A photographer named Joseph T. Zealy took them.
And the subjects, this is absolutely central, 7 enslaved individuals.
7 people. 5 men, including one named Renty, and 2 women, one named Delia. And what makes them so significant, historically speaking, is they're some of the earliest known photographs of enslaved people, period.
But here's where the story takes a really, really dark turn. They weren't made to, celebrate or even just document the lives of Renty and Delia and the others. Not at all.
No, they were specifically commissioned by a Harvard zoologist, Louis Agassiz, and his purpose was, well, it was pretty disturbing.
He wanted to use these images to try and prop up his pseudoscientific theories.
Right. Agassiz was a big proponent of polygenism, this completely debunked idea now, that human races have different origins. The sources are very clear on this. His whole project was designed to lend, quote, scientific legitimacy to the myth of white racial superiority.
Basically, to justify slavery.
Directly. To perpetuate American slavery. That was the goal.
And the way the photos were taken... It was just awful. I mean, completely without consent. The individuals are shown shirtless, photographed from multiple angles like specimens.
One source describes how their bodies were treated as, and this is a quote, items of public, indeed pornographic display, just reduced to evidence for this deeply racist project.
Okay, so flash forward, many, many years, and this history comes roaring back with Tamara Lanier.
Right. Mrs. Lanier identifies herself as the great-great-great-granddaughter of Renty, the man in one of the photos. She calls him Papa Renty.
And her fight for recognition for these images, it started quite a while ago, back in March 2011, actually.
Yeah, she contacted Harvard then, told them about her family connection, asked them to verify it, asked how these daguerreotypes, which are held at Harvard's Peabody Museum, were being used.
And Harvard's response initially?
Well, according to the sources we look at, those initial requests went unanswered, or at least weren't fulfilled.
Okay, so she didn't give up. The situation got more urgent for her in October 2017.
Right. That's when she found out Harvard had actually used Renty's image on the cover of a publication and shown it at a conference.
Without telling her, presumably.
That seems to be the case. So she renewed her demands then, asking for the images. And again, the sources say that demand also went unacknowledged by the university.
Which eventually led her to court.
Exactly.
Yeah.
In March 2019, Tamara Lanier filed a lawsuit against Harvard. The core argument was that the photos were taken without consent from Renty and Delia, and so Harvard was unlawfully holding on to them.
And she was seeking not just damages, but actual possession of the daguerreotypes.
That's right. She wanted them returned.
So this lawsuit really set up a clash, didn't it, between sort of traditional property law and these really deep moral and historical issues.
Absolutely. Lanier brought several types of claims. Some were property related, like replevin and conversion.
Which are basically legal ways of saying, give me back my property or pay me because you wrongly kept my property.
Exactly. And she also brought tort claims, things like unauthorized use of image, violation of the Massachusetts Civil Rights Act, and crucially, negligent infliction of emotional distress.
Okay, so what was Harvard's defense?
They had a few main arguments. First, that the claims were too old, filed too late, past the statute of limitations.
Time barred, right.
Time barred. Second, they argued Lanier didn't actually have a property interest in the photos to begin with. Common law usually says the photographer owns the photo, not the person in it.
Ah, okay. So Renty and Delia didn't own them, so they couldn't pass ownership down.
That was Harvard's argument. And they also said the unauthorized use claim didn't work because Renty and Delia were deceased.
So the first court, the trial court, how did they rule?
They sided with Harvard, pretty much across the board. Granted Harvard's motion to dismiss all the claims. They agreed Lanier lacked that property interest under common law.
And the other claims?
Dismissed as time-barred or just not meeting the legal standard for a plausible claim.
Okay, so it looked like that might be the end of it, legally.
But it wasn't. This is where it gets really interesting. The case went up to the Massachusetts Supreme Judicial Court, the state's highest court. And in 2022, they issued a ruling.
And what did they say?
Well, it was mixed. They affirmed in part, meaning they agreed with the lower court on some things. Specifically, they agreed that Lanier didn't have those traditional common law property rights to the photos.
Okay, so the property claim was still out, but...
But, and this is the crucial part, they vacated in part. They overturned the dismissal of one specific claim, the negligent infliction of emotional distress.
Wow. So that claim could go forward. How come? Why did that one survive when the property claims didn't?
The court found her allegations were strong enough, plausible enough, to potentially support that claim. They talked about Harvard having a duty of care towards Lanier.
A duty of care based on what?
Based on Harvard's connection to the, quote, horrific conduct by which the daguerreotypes were created. Agassiz project, the coercion.
Right.
And that duty was combined with the fact that Harvard knew about Lanier's claim to be Renty's descendant. The court basically said a jury could find that Lanier's distress, and she reported physical symptoms, like insomnia and nausea, was a foreseeable consequence of Harvard's actions related to these photos.
And did the court point to specific actions by Harvard?
Yes, they highlighted things they suggested could be seen as extreme and outrageous conduct, like using Renty's image on that book cover and at the conference without informing her. And also, a museum spokesperson publicly denying her ancestral connection. That was mentioned too.
So the court was really linking Harvard's present-day actions back to the original creation of the images.
Absolutely. They had this really powerful line in the ruling. Harvard's present obligations cannot be divorced from its past abuses. That really sums up their reasoning on the emotional distress claim.
Okay, so that legal path was, well, complicated. But this whole case pushes us beyond just the letter of the law, doesn't it? Into these much bigger ethical questions for institutions.
It really does. And that law review article we mentioned critiques the court, suggesting that even while letting the emotional distress claim proceed, maybe it was still being a bit too narrow.
How so?
By, quote, imprudently restricting itself to common law standards arising from fundamentally incompatible precedent. Meaning, the laws about photo ownership were made for situations where people agree to be photographed.
Which clearly wasn't the case here. These were coerced images for a racist project.
Exactly. So are those old precedents really the right tool? And this brings up fascinating ideas like quasi-property interests.
Quasi-property, like sort of property.
Kind of. The law review notes that courts sometimes recognize rights, like property rights, in really sensitive situations dealing with human remains. Is an example based on, basic fairness or human dignity. Could that idea apply here? To images taken under coercion used for eugenics? It's a really challenging question.
Yeah, it is. And it connects directly to ethics in archives and museums too, right?
Absolutely. We looked at guidelines from the Society of American Archivists. They talk about seeking diverse perspectives, consulting communities of interest, people with connections to the materials.
Not just deciding things internally.
Right. Promoting access, yes, but also recognizing privacy, encouraging respectful use, especially of culturally sensitive stuff, by talking to the communities of origin.
And they mention a social responsibility that goes beyond just the institution to the public good.
So when you look at Harvard's alleged initial lack of response to Lanier, using the image without consultation, the public denial, how does that stack up against these ethical guidelines? It raises questions.
And Harvard itself has been publicly reckoning with this history, their Harvard and the Legacy of Slavery initiative.
Right. They put out a big report acknowledging the university's financial and intellectual ties to slavery, including supporting race science like Agassiz. Their stated goal now is to tell the truth and mend enduring harms. They
talk about memorialization, partnerships with historically Black colleges and universities.
Yeah. So the handling of the Lanier case, even with the court battles, It fits right into this bigger picture of the university trying to figure out how to deal with its own difficult legacy.
Which brings us finally to the resolution, May 2025. After 6 years in court, and really a 15-year campaign by Tamara Lanier, settlement.
Yes, and it was a landmark outcome. Harvard agreed to relinquish ownership of the daguerreotypes.
All of them, not just Renty and Delia.
All 7 of the individuals depicted in that Zealy collection. Harvard gave up ownership.
Wow. Okay, so where are they going? Did they go to Mrs. Lanier?
No, not personally. They're being transferred to the International African American Museum down in Charleston, South Carolina.
Charleston, that's incredibly significant. That's where the individuals were enslaved when the photos were taken.
Exactly. It's a very symbolic and contextually important move. The resolution also included a financial settlement, but the amount wasn't disclosed.
And how did Lanier and her team react?
They called it a historic settlement, an unprecedented win for descendants seeking justice for ancestral harms, a step towards reparative justice. Attorney Ben Crump was involved, a well-known civil rights lawyer.
I saw something about Louis Agassiz's descendant, too.
Yeah, quite a poignant detail. Susanna Moore, Agassiz's great-great-great-granddaughter, actually celebrated the settlement with Tamara Lanier. Moore called her ancestors' project deeply racist and said this shows the meaning of these objects in museums can and should change.
That's powerful. What did Harvard say officially?
Their statement mentioned they'd long been eager to place the photos with another institution, and they were grateful to Lanier for starting conversations. But they also noted they hadn't formally confirmed her specific genealogical link.
Okay. And the museum receiving them.
The IAM CEO called it a moment 175 years in the making and committed to working with Mrs. Lanier on how the images will eventually be displayed and interpreted. The goal, they said, is to finally celebrate their humanity.
It sounds like a major step. But did Lanier achieve everything she set out to?
According to one of her lawyers, one thing is still outstanding. They feel Harvard hasn't publicly acknowledged Lanier's specific connection to Renty, or fully reckoned with its institutional role in perpetuating slavery in the U.S. So maybe not full closure on all fronts from her perspective.
So, okay, let's try and synthesize this. You look at the whole arc, at the horrifying origin of these photos, the long legal fight testing old laws, the ethical debates, and this final settlement. What does it all tell us?
Well, for one thing, it really throws into sharp relief how limited our traditional legal tools like property law can be when we try to apply them to the legacies of slavery and extreme coercion. The law just wasn't really built for that. Yeah, it creates this huge tension, doesn't it? Between these big, powerful institutions holding artifacts and the descendants who have these profound moral claims, who experience real emotional distress tied to those objects and their history.
But maybe the positive takeaway is that it shows persistence can make a difference. Legal challenges, even if they don't win on every single point initially, combined with public pressure, ethical arguments, it can push institutions towards making decisions that maybe go beyond strict legal necessity.
Towards stewardship and repair rather than just ownership.
Right. And maybe this provides something of a model, or at least a point of discussion for other similar situations, involving sensitive historical items tied to past injustices.
A path that involves actually collaborating with descendant communities and maybe transferring items to places like the INAM here that can really focus on the humanity and the full story of the people involved, not just the object itself.
So just think about that journey for these daguerreotypes, made as tools for racist pseudoscience, became contested artifacts in a major legal battle, and now they're heading to a new home with the stated purpose of celebrating the humanity of Renty, Delia, and the others, and telling their stories. It's quite a transformation.
And maybe the question to leave you with is this. Our legal systems might struggle sometimes using old frameworks to deal with these deep historical wounds. But what does this particular case tell us about the power of other forces, like individual perseverance, evolving ethical standards, and maybe finding collaborative ways forward in shaping how we confront and perhaps begin to mend the really difficult truths of our past?
Yeah, that's definitely something to think about as we consider history, memory, and what real accountability looks like, especially when dealing with harms that reach back centuries.